Since this appeal is confined against an order of acquittal of sole opposite party, I need not go into the details of evidence adduced at the trial except those which relate to the opposite party. Upon perusal of the materials available on the record, I notice that the only evidence which has come against the sole opposite party is that on a particular day the deceased had gone to the house of the opposite party where the main accused was present and had taken her photographs and video clips. Over and above the same, there is no evidence adduced at the trial against the opposite party. A question would arise, therefore, as to whether the opposite party could have been held guilty of the charge of offences punishable under sections 306 of the IPC on the basis of said offence. Section 306 of the IPC provides for punishment against a person who abets commission of suicide. Section 107 of the IPC defines abatement of a thing as follows. Abatement of a thing: a person abets the doing of a thing who first instigates any person to do that thing, or secondly engages with one or more other person or persons in any conspiracy for doing of that thing, if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing, or thirdly intentionally aids by any act or illegal omission the doing of that thing. Evidently thus a person abets doing of a thing only when he instigates any person to do that thing or engages with one or more other persons in any conspiracy for to doing that thing, or intentionally aids by act or illegal omission to doing that thing. In order to establish abatement as a crime, above are the three essential ingredients which must be established by cogent evidence at the trial. In case of Netai Dotto versus State of West Bengal, reported in 2005 2 SCC 659, the Supreme Court dealt as to what would be the essential ingredients of abatement under section 107 of the IPC and held in paragraphs 6 and 7 as follows. In the suicide note, except referring to the name of the appellant at two places, there is no reference of any act or incidents whereby the appellant herein is alleged to have committed any willful act or omission or intentionally aided or instigated the deceased Pranav Kumar Nag in committing the act of suicide. There is no case that the appellant has played any part or any role in any conspiracy which ultimately instigated or resulted in the commission of suicide by deceased Pranav Kumar Nag. Apart from the suicide note, there is no allegation made by the complainant that the appellant herein in any way was harassing his brother. The case registered against the appellant is without any factual foundation. The contents of the alleged suicide note do not in any way make out the offence against the appellant. The prosecution initiated against the appellant would only result in harassment to the appellant without any fruitful result. In our opinion, the learned single judge seriously erred in holding that the first information report against the appellant disclosed the elements of a cognizable offence. There was absolutely no ground to proceed against the appellant herein.